serving a lot of alcohol, you that's a different factor than if you got a sit down restaurant where people are coming in, maybe ordering a bottle of wine with dinner, and it's a different atmosphere.
Absolutely.
Okay.
Follow that question up with
Sir
this
Grissom.
question. These are factors that drive liquor liability insurance pricing. You're not telling us that's what's occurring here in South Carolina because we don't know.
Correct. This is taken from an agent, a general agent, and there's some agencies and insurance companies that really do a good job. It's in their economic interest, obviously, to put out guidance as to what bars can do to limit their liability.
But we don't know that they're, well, we have no idea whether these are the factors. They may just be charging everybody twice what they ought to be charging
Yep.
everybody.
True. This is not South Carolina specific.
Okay.
That's
Just wasn't
exactly
sure
right.
that-
But-
I mean, I think all of us understand these things should impact the premium, but we're not saying that's what's happening in South.
Correct, because we don't know, because we don't have the
Okay.
rate filings, we don't have the ISO methodology. The point that I'm trying to make with this slide is this: if you run a bar where there's music, whether it's a piano bar or a karaoke bar or something else, that's the type of bar you're running. That's what you want to do. If you have a bar in a college town, whether it's Columbia, South Carolina, or Columbia, Missouri, that's what you have. That's where the bar is. You can't control those things once you open the bar, but there are things that you can control, and those are the bottom four lines. You can certainly hire experienced management. You can certainly do background checks on employees, including especially bouncers. You can do conscientious of training of bartenders, and you can have a very specific policy for dealing with intoxicated patrons. So regardless, I mean, it's sort of running a bar is sort of an inherently dangerous activity. So you have to accept that. But once you accept that, and you do as much as possible to mitigate that danger. In my report, I also have a page from another agent recommending certain policies that bars should follow. And let me just mention two of them. One is to document any interaction with intoxicated people, to keep a logbook and to document this stuff carefully. And then a second thing is, and this is common sense, but I'll give you examples which go against common sense. Don't sell beer in 24-ounce containers. Don't have happy hour that goes on for 8 hours. When I was a kid, it seems crazy now. It seems impossible now. But when I was a kid, I grew up in the Jersey suburbs. The New Jersey drinking age was 18. I'm sorry, it was 21. New York was 18. So when we were 19, when we were college kids, we would drive into New York to a place called Steak and Brew. Steak and Brew was famous in the Jersey suburbs because at that time they charged like $6.99 for all the steak you can eat and all the beer you can drink. So can you imagine a bunch of 19-year-old kids driving in on Route 3 through the Lincoln Tunnel, going to Steak and Brew in Manhattan? Well, Steak and Brew doesn't exist anymore, and obviously I'm not anti-alcohol, but it's a good thing it doesn't exist. And it may well have had something to do with the fact that they found insurance, understandably, too high to get too high for the business to make sense. But anyway, that's one of the things that can certainly is certainly within the bar's control. Don't sell beer in 24-ounce containers or these big things, and don't have happy hour going on for 8 hours. Okay, so what are my suggested potential solutions? It doesn't mean that all of them, I wouldn't expect all of them to make sense to all of you, but for whatever it's worth, let me mention them. First, enforce the laws that are on the books. Whatever the drunk driving law is, enforce it conscientiously. Doesn't mean you harass people, but enforce it as conscientiously as possible. The same thing with whatever laws are on the books regarding the standards that bars and restaurants have to meet. Enforce that conscientiously. The second little entry there is enact the server training bill. My understanding is there's a bill pending that would require bars to train their train their employees to undergo, I think it's a 4-hour course. You can question whether this 4 hours is going to do any good, but if people take it seriously, it really can. I think I mentioned when I was last here, I work in a bar on Saturday nights. We've had our same bartenders since 2014, and they are very conscientious. They've been trained well. They are great at spotting potential problems and not escalating the problem, but de-escalating it. So enacting a server training bill, I think, is very important. Third, we've talked a lot about the liquor liability data. I won't talk about it anymore. Oh, okay. This is the department's liquor liability data. Yeah. Whatever the department collected, let's see the underlying data, not just these charts, which are helpful, but the data that produces these charts, particularly the company by company data. Release ISO data, obviously, I think that's very important. Fifth, South Carolina and other states, their insurance departments have websites at which they usually do it for auto, where people, and sometimes homeowners, where people can go and get a price estimate by not a binding quote, but a price estimate by punching in their rating criteria, like their driving record or the miles that they drive or where they live. And you can get auto insurance quotes in a lot of states from, State Farm, Allstate, Geico, Progressive, all the major companies. That could be done with liquor liability if we had the data. Technologically, it's much, much easier now to do it when I was insurance commissioner in the 90s in Missouri. And then finally, rate regulation, and there are different types of rate regulation. The most regulatory is called prior approval. That is, a company cannot charge its rate unless and until it's approved by the department. And the standard for whether a rate can be approved is whether it's excessive, inadequate, or unfairly discriminatory. There are other types of regulation which are a little softer, which say that the company can charge what it wants in the first instance, but the department has discretion to have a hearing after the company files its rates. And if it finds those rates are inadequate, excessive, or unfairly discriminatory, it can roll back those rates. Both of those systems depend, though, on having the rate filing filed. So I guess that's what I'd close with. If there's, obviously, I think the ISO liquor liability data is essential, but I think even more essential is having the department get the rate filings from liquor liability companies. Thank you, Mr. Chairman and members of the committee. I appreciate your hearing me out.
Thank you, sir. Appreciate that. And first, I'll turn to the committee, see if you have any further questions of Mr. Engel.
Mr. Chairman,
Yes, sir. Senator from York.
if you would, and I know you've done this, but in a 30-second, encapsulate this for me. Explain to me why an ISO rating is not linked to the form of liability a state has. Whether pure, joint and several, pure several, why are those things not linked?
Because there are so many other legal doctrines that affect the rate. I mean, to take, I think most people would understand, there's some states where there's a cap on damages of a certain amount, say a very low amount. There's some states where there's no cap. There's some states that have a 2-year statute of limitations, some 3, some 4. There's some states where the standard of liability is regular negligence. There's some states where it's recklessness or gross negligence. So all these legal doctrines produce the legal climate, and you can't rely on just one. And what we found based on the correlation we did is one thing is whatever the liability environment depends on, it doesn't depend on joint and several liability.
how is that, and how is that possible? Because when I look at an ISO rating for Florida, they're pure several, which is the most defense friendly. They have a 3. Georgia has a 4, most defense friendly. As you move away from that, South Carolina, North Carolina with modified, and North Carolina with a least defense friendly, although they have contributory. So I wouldn't say that's true. We have higher. So I'm curious. I mean, the 2 states with the most defense insurance based friendly laws actually have the lowest ISO ratings of states that touch us, which is compared in every one of these charts. I didn't get charts comparing me to Maryland or other thing. I got charts comparing me to the states that touch South Carolina. So how do you reconcile that?
Because there, as the chairman pointed out, the North Carolina has contributory negligence.
It would seem to me that North Carolina should even have a lower ISO score than anybody else.
Say it again. I'm sorry, say it again.
Well, wouldn't that make sense that North Carolina should have a lower score?
No, because there's no single doctrine that the liability environment depends on. You can see there are plenty of states, if you look at my table 1, where there's pure joint and several liability, but there's a 0 score. My point is not that if you enact pure joint and several liability, rates are going to go down. My point is that you've got to look at the totality of legal doctrines in the state, and based on that, determine what to do. And obviously, I realize there's a controversy. Some people want to restrict liability. Some want to keep it the same. Some want to keep it expanded. And my only point is, before you do that, whatever your view is, find out what it is that drives insurance rates.
Your suggestion number 2 was strictly enforce the laws against drunk driving. If we have the second highest incidence of drunk driving caused deaths in the nation, would it not make sense that we actually strengthen those laws? Because they're not, I mean, whether they're being enforced correctly or not, that strengthening them, I mean, when more people die than not DUI, shouldn't we be strengthening them?
Yes.
So your recommendation is actually to strengthen our DUI laws.
Yes.
Enforce and strengthen.
I don't purport to be an expert on it, but yes, I think drunk driving is a terrible thing, and we've all suffered, I think, because of it. And so I'd strengthen them as much as possible.
You do not recommend any sort of changes, action of a dram shop law, changes to joint and several. You don't recommend any of those changes at all. Is it because you don't feel that those changes will change our IS, or you don't know to what extent they would change our ISO rate, or you just don't believe we should enact any of those changes at all?
I don't, two different answers for the 2 different questions. I don't believe that you should change joint and several liability, because based on the research I've done, I've found that joint and several liability is not a determinant of the liquor liability environment in the state. As far as changing laws, I mean, the standard tort reform debate, as far as changing laws to make it easier or tougher to recover, I'm not taking a position on that right now. I'm saying that whatever side you're on, find out what the data is before taking any action.
So like the state of Alabama's instituted some dram shop laws over the past year and a half. You have them with an ISO of 10. Do you know if their ISO rating changed post enactment of those laws?
Yeah, I believe that it did change, and I thank you for pointing out Alabama. The data I relied on was before Alabama changed its laws, but my data is as of September 22. So yeah, I know that Alabama changed its law. I don't know the details of it. My understanding, it was some sort of compromise.
It's a visible intoxication defense. So I guess my question is, did their ISO rating lower from having done that?
Yes.
To what? Do you know?
No.
Okay. Can you find out and let me know, and let this committee know?
I'll try, but keep in mind, the ISO numbers I got were from an agent who got the ISO numbers. They're not public. But I will absolutely try, and as soon as, if I'm successful, I will get them to you immediately.
Thank you, Mr. Chairman.
Yes, sir. Senator Richland.
You have a chart called Liquor Liability Incurred Claims per $1 million of earned premium. And it shows that we have the highest incurred claims for $1 million of premium, right?
Liquor liability incurred claims per $1 million of earned premium?
Yes.
Yes.
Okay. Now, here's my question, and it has numbers. When, for instance, if you look at 2021, it shows 13, that would be 13 claims per 1 million of earned premium, right?
Yes.
For South Carolina, 3 for Georgia, 3 for North Carolina, 5 for Georgia, 3 for Florida, correct?
Yes.
And I want to make sure that I'm not misinterpreting this, but does that mean we have more claims in total? What I'm trying to get is, do we have more incidences which would require a claim on liquor liability in South Carolina than they do in our neighboring states?
I don't know. This is not my chart. This is the insurance department's chart.
Right.
And I question it. It seems crazy to me that there'd be that big a difference among the states. I don't know when they say incurred claims. I don't know whether that includes only claims with payment, claims closed without payment. It's possible that the different companies interpreted it in different ways in different states. I just don't know.
Wouldn't it average out over, I mean, state by state? Wouldn't everything be apples to apples or not? Or so,
No, it's quite possible it's not apples to apples here.
okay. So what we really need to know, and of course you'd have to get this from filings by the insurance company, is how many claims did you have last year? How many of them did you pay? How many of them did you not pay? What was the, earned, incurred claims for $1 million of earned premium, right? We need to know those exact numbers so we can compare apples to apples
Yes.
by state.
Yes.
And we don't know that because there's no filings. And
Correct.
there's no data.
Correct. Now, again, this is the insurance department's slide. They may have underlying data that they can.
I think Senator from York asked them if they had that data when they were here, and I think they said no. They do not have that data. They could not. That's right. They couldn't give us that data because that data was confidential.
Okay. Well, not that Missouri is the repository of all insurance wisdom, but in Missouri it would be public.
So we need to make sure that whatever legislation we pass has a provision. This is public information.
I think it's being public information is very important, particularly in a state that's a non-regulatory state. In Missouri, we had very little. We had no prior approval. We were a very non-regulatory state, but we put out a lot of information.
Would you recommend? Do you recommend that liquor liability should be prior approval?
I don't know. I don't know. I think the first thing to do is to get the rate filings and see what they say.
I mean, we got to pass legislation to get the rate filings. So we got to pass legislation. Do we pass legislation saying it's prior approval, or believe that for another legislature another day?
Before you go, I mean, I'm going to hem and haw about that a little
Chicken
bit.
or egg?
Sorry?
Chicken or egg?
You could, but if you didn't want to go all the way to prior approval, you could have what's called file and use. That is, they have to file, and then the insurance department has the authority to roll back the rate. It can investigate.
File and use.
Yeah.
Okay. Thank you.
Senator from Charleston.
You keep referring to an agent. You received this information from an agent, or you're not talking about an insurance agent? You're
Yeah,
talking about a agent that what are you?
Yeah, I'm
referring
talking
to?
about on the internet. There is an agent that has disclosed all these ISO numbers by state, and I just used those.
Okay, and did you research any? I'm sure there's a lot of. I would think there's a lot of kind of national. If you look at the probably business schools have analyzed this, law schools, but is there much data or studies out there published? And and peer reviewed by professors and about these same metrics and whether and the impact that the different models of liquor liability to different in the different states have made a difference? I mean, it seems like you did this yourself. Is there something, did you look at any of the published research on this or statistical analysis on this?
I agree with you that you would think that it exists, but I was unable to find any. Doesn't mean I could have overlooked something. Maybe there's something on the internet
You
someplace.
looked for that and you
I
didn't
sure
find
as
it.
I sure as heck did. I spent a lot of time looking for things that I didn't find, and in a way, it makes sense, and that's because the industry depends. The industry is structured by line, so there's a lot of data by line. The line is other liability, but there are a lot of sublines of that. One of which is liquor liability, and the NAIC doesn't collect data on that. I tried to find other states that did. I was unable to find some. Had I found it, I sure would have used it.
You'd have thought even the insurance companies would.
Well, I
would-
called
would commission
ISO.
something like that. It may be a little bit biased, but you would think they'd commission it. You didn't find that?
I called ISO, and guess what they told me? I can't repeat it here.
Sim-
The chart, I realize this isn't your chart, but it's the Department of Insurance chart, but the chart that talks about incurred claims per $1 million of earned premium. It seems like there are two words there that got to be terms of art, right? Because it could just say claims per 1 million of premium, but it uses the word incurred claims and earned premium. And to me, those suggest that I don't know if incurred means the year that it happened or the year the year that the event happened or the year the claim was made or the year the claim was paid. And then the earned premium, is that different than the actual premium? And since you were in the insurance review industry, do those two modifying words mean anything?
Yeah, both are important questions. There's earned premium and there's written premium. The written premium is the amount that you collect in a year, but the earned premium is the amount that is correlates with the term that exists in a year. So that was said very inarticulately. But if you pay $100 in premium for an annual policy that takes effect July 1st, you've written $100 as of December 31st. You've written $100, but you've only earned 50. So that's earned and written are pretty well known. Incurred can mean a bunch of different things, and I'm unsure as to what it means here, and I'm unsure as to whether each company in each state interpreted the same way.
Well, that's what I'm concerned is that we asked the question. We sent these states a questionnaire or we invited them to share information with us. And it may not be apples to apples, right? They may have interpreted what we were asking to be one thing and we reported it as we thought they meant it, but it could be two different things.
Exactly right.
Okay, so it seems to me that we probably, well, let me ask it, how do we know how many claims were made in a given year? Does anybody keep that data? I mean, you file your claim against Allstate and I file my claim against State Farm, but does anybody in government or in the insurance world say there were 17 claims filed in South Carolina last year?
Typically not, certainly not without the rate filing, but you use the term file, which is a better, that's less ambiguous. It's pretty clear. Well, no, but how do you define a claim? If
the person went to 3 bars and you filed against 3 different entities, is that 3 claims or is that 1 claim?
Well, also, is it a claim if you just write the insurance company, if you don't sue? It's unclear what they mean by claim, and it's unclear what they mean by incurred.
Right, because some people make claims and never follow up on them, and the insurance
Sure.
company denies the claim, and that's just sort of the end of it. It's just denied.
True.
Does that count as a claim or not? Would be the question.
Yeah, I don't know.
Okay.
Anybody else? So, Mr. Angoff, when we first started this meeting, we had this bill of 533, which is basically it just addressed the issues in the case Smith v. Tiffany. Are you familiar with the Smith v. Tiffany case? Where
No.
not okay, it's okay.
No, I'm not.
It's all right. It's a basic question. And so the issue became for something that I think that the senator from Charleston and Senator from Orangeburg and I were here when we had a change back in maybe 2005, where we had what we call the empty chair on joint and several. And so in our state, what we have is that if there is several defendants and one person settles before they get to court, then they're not listed on the verdict form. And so the others that are listed are still there in the end for the case. So the case would then go to the jury with those individuals listed. The individual who has already settled is not listed. Here's the catch, if you will, is that those individuals would still yet have to end up having a greater than 50% at fault for them to have to end up recovering, because we set a threshold for that amount during this debate. Where we are in this very complicated puzzle, if you will, is that when we started having our committee meetings, the question was initially asked and we asked DUI to determine why rates were increasing for bars and restaurants. We heard a lot of testimony from them. And so we didn't have anyone there to speak during that time. And so we talked about having someone from the Department of Insurance. And this is for the benefit of everybody. It just has to go through Mr. Angoff while he's there. I asked specifically for the Director of Insurance if other legislative or policy matters pertaining to increasing access to alcohol had affected the policy limits, which is what you're saying is that restricting DUI laws. We have Emma's Law, other things here that may end up doing it. We have .08. We have some rebuttable presumptions. We know it's not against the law to drink and drive. We're at number 8. We don't have very lax laws, but that's for to be determined at another time. DOI then was coming in. The issue that we have that is still yet outstanding with those, and for the audience too, intentional conduct. We got to see how that affects it. We got to see what happens with alcohol cases. Drug cases are still pure joint, and several with no 50% threshold. And so the senator from Orangeburg asked the director whether there was a way to break down the incidents which occurred as a result of on-premises and off-premises consumption. So we're going in and we're trying to tackle this web of what happens with bars and restaurants and consumption and try to get to joint and several liability. And so this committee is very, very wise with a bunch of experience, is that do they connect? And so we're trying to see if that was true, to get evidence-based, get the data to see if we can justify a change in our state so that people can have restaurants and bars and pay a premium, so we wouldn't have more premiums. We'll see, the payouts were greater than the premiums overall. And so it's a question that's driving our business out of existence. And we get these reports where these restaurants and bars are popping up all the time. And if you notice, I had the witnesses to be sworn in because at one time I thought, and some of the committee may be able to help me, I thought that we only had a couple of insurance folks that were selling insurance in the state, 2 or 3, I think that number was. And then now I understand that there's like 14. And so how do we put this into existence so we all want to make certain that we can exist here. We don't want folks having to pay more premium than there are payouts, but we don't want to end up coming in and change something unnecessarily whenever it's not going to end up making a difference. And the last thing I would just say is that we have to be careful what we ask for in these committee processes, because you might get it. We've been through this committee process before. We tackled venue and other issues back in 2005. We ended up tackling joint and several. I mean, I'm not certain if the issue is, you know, let's look over here, but this is what we really want. And so that long way of describing this, two other points. Senator Campson asked, this is from my notes earlier, how the 198% figure regarding payouts versus money collected through premiums compared to other states. We got a report that came back from the Department of Insurance where they looked at 4 of the states, I think it was, 4 of the states, with 3 other states in it, including us. And is that a sufficient amount of states to get together? Let's look at the summary of what they all have done compared to South Carolina to see where we fit. And then what we had from the Department of Insurance and Director Wise, who's not here, but they were aware, is that they were giving us the data. And here's the issue that I have, so that I can continue to work through this committee process, is that we're asking for the data, and we've been asking for it now, and we're getting challenged to say we're going to have meetings, and we're trying to have a meeting, and we don't have enough data to you can't get to the data. Is that right?
Yes,
Okay.
that's right.
And so these folks are filing bills to try to end up getting data. There is a privacy issue as it relates to the data, and so you're not going to be able to get it. So you're not going to be able to assess it, and so it doesn't matter what we're doing here. We're not going to get a chance to have this as an evidence-based approach to see if the data would be able to lead us in the direction as to where we need to go, because you don't have that information available. That's a long statement. Is that true?
My understanding is that the data can be public as long as you don't identify any particular individual. And in Missouri, we never did. I don't think departments do. So I don't see any reason why it can't be public. I will say, Mr. Chairman, and I hate to sound like a broken record, but to answer your questions, you got to have the data, all of it, company by company, from the insurance department, and you've got to have the ISO liquor liability scores.
Okay. Any further questions of Mr. Angoff? Thank you for coming here again. I'm sure you'll talk to your folks and be standing by if we have any questions, or we have anything else that we'll need to end up presenting. So
Thank you for having me.
Okay. With that, we've been going for a little while now. We have a few people that have wanted to end up speaking today, and we're going to probably hear from them briefly. I think Jay Thompson, are you here? Mr. Thompson, you desire to speak today? Please come forward. Okay. Anyone else that has prepared, and anyone that has traveled from a distance, we will try to accommodate you to the extent that we can. Okay. Come on forward, Mr. Thompson. Thank you for coming. Okay, before that, and as a practice, we before this committee, we are asking for each witness to end up taking the oath. Okay, raise your right hand. Swear to tell the whole truth and nothing but the truth, so help you God.
I do. Thank you, Mr. Chairman.
Tell us who you are and who you represent and where you're from.
Thank you very much. Are you able to hear me?
I am. Is your mic on? Yes, sir. We got you.
Thank you, Mr. Chairman, members of the committee. Thank you for the honor of being allowed to speak this, I was about to say afternoon, evening. I will be brief. My name is Jay Thompson. I am a civil defense attorney here in Columbia. So I am on the defense side of these types of lawsuits. I've been practicing in this statewide for 17 years. I practice with the Murphy and Grantland law firm here in Columbia. I'm also the secretary of the South Carolina Defense Trial Attorneys Association. And so I come here today speaking on behalf of that association and its current 851 members. First, I commend the committee for what has just been described as an evidence-based approach. That is a very good way to approach this. I commend the committee for your desire to seek data. And data does not always mean numerical metrics, or evidence does not always mean numerical metrics. There is value to anecdotal evidence as well. And so I commend you for seeking out all of that type of information. The statute that, or the bill that is proposed, 533, is not at its core a liquor liability bill or an insurance bill. It is a bill to amend the provisions of the Uniform Contribution Among Tortfeasors Act. That word uniform is part of the existing statute. That's what it says it is called. Our state's law is not uniform. In fact, most states are not consistent with one another. And so we're not unique in being different. We do have a Contribution Among Tortfeasors Act that is pretty unique. It's different than what you see in most other states. In fact, after practicing for a number of years, occasionally in other states, I personally am not aware of any other state that has or has had allocation provisions in its Contribution Among Tortfeasors Act that are similar to the ones that South Carolina has. The statute, as Mr. Chairman, as you alluded to a few moments ago, the existing statute requires a jury to allocate 100% of fault among, quote, defendants, meaning defendants who are parties to the case at the time it goes to the jury, without regard to other potential liable entities who either are not part of the case, the lawsuit, at the time it goes to the jury, or may not ever have been part of the lawsuit at the time that it was filed. That allocation provision is the part that is the most troubling to the South Carolina Defense Trial Attorneys Association and its members, because in our experience, it confuses juries. We have found, as I believe many of you have probably found, juries are really good at reaching the correct result. And when we provide them transparently with the proper information and an understanding of the law, they do a really good job. However, this particular aspect of our state's law is one that when we interview or speak with jurors after the conclusion of a trial, we almost uniformly, almost every time, find that if there is a situation in that case where there were multiple defendants and then all of those defendants did not go to the juries do not understand what their expectations are in allocating liability amongst the parties, because they are instructed, as the statute requires them to be, they are instructed that their allocation of liability must add up to 100%, but there may be entities or people that they believe to be liable, and they are not allowed to allocate percentage to them, and they don't know what to do with that.
Well, does the form also have the percentage of fault assigned to the plaintiff?
The verdict form?
Yeah.
Yes.
Okay, so when it has the percentage assigned to the plaintiff, and they say 100%, you're talking 100% of the amount that is left.
Could you repeat that, Mr. Chairman? I'm sorry.
Okay,
I
so
think so. I just want to make sure I
40%
understand.
40% to the plaintiff, 60% to the defendants. How do you apportion? How is that done
So
for the benefit of everybody?
the statute requires that the plaintiff and the defendants who are still in the case at the time it goes to the jury must be allocated or apportioned numbers that add up to 100%.
So those on the side of this of the 60% of that example, see, it had to be greater than 50%, correct?
If there's only one of them,
How about if it's two?
it could be 30 and 30.
Right. So, but the thing is, on that side, it has to be more than 50%.
In the instance you're describing, yes.
Or any other instance, 40, 49 and 4.
Sure.
Still more than 50%. So it has to be allocated on that side. Tell us what happens if it's more than 50% assigned to the plaintiff?
If more than 50% fault is assigned to the plaintiff and you're not dealing with one of these exceptions where joint and several liability doesn't apply, then the plaintiff would be barred from recovery.
Barred from recovery. Okay. All right. Go ahead.
If you are dealing with one of those exceptions where joint and several liability doesn't apply, that may not be the case.
Have you ever done any plaintiff cases?
Very rarely.
Very rarely.
Very rarely.
And so you've been practicing law for how long?
17 years.
So you're right there on the brink of whenever this thing was going,
So-
right? So you came in, so you've only known this system.
That's correct. I graduated from law school in 2006. The 2005 was when the act went into effect. So
Right.
I did not practice under the previous system. That's
You didn't have to learn the old one, then have to relearn the new one. So
learned it at law school,
that's
but
an
otherwise, no.
That's an advantage.
That's correct.
And so would it be your opinion as to whether in South Carolina that we have a history of runaway verdicts?
That's difficult to answer. We have unquestionably seen an increase in large verdicts since COVID, and that's not unique to South Carolina. So I do not believe that's something that's specific to
I'm
our
just
state.
curious. You have a great firm. Some of my good friends that are JR and John and the rest of those guys, they do a fantastic job.
Thank you, Mr. Chairman.
I'm just trying to just see if that's what you're seeing, because we hear that here. I don't see that a lot, and we don't see a lot of verdicts at all, really, because we're so many cases of mediations. And so the question is that are we seeing, runaway verdicts, high amounts, and how that's governed? So when we try to fix something, we got to figure out why are we fixing it.
Sure. So as far as runaway verdicts, there are a lot of challenges with that concept.
Sure.
One of them is, what does that phrase even mean? We hear the phrase nuclear verdicts. Again, what does that phrase even mean? We have seen an increase in large verdicts. I don't know that anyone has data-driven metrics to explain why that is. There's unquestionably a sentiment out there that something changed in 2020 and since, and with COVID. There's unquestionably a sentiment in our state that there are certain aspects of our law that do lend themselves to larger verdicts in certain areas than you might see in other states. It's anecdotal.
So in the last time that we were here, we had an expert that came in and also testified, and he welcome to end up coming back as well. But he got his data from Lawyers Weekly and said he saw a lot of verdicts a lot of settlements that were pretty high. And so, but those were not just, they weren't verdicts, they were settlements in different cases. And you're saying that there's not a lot of data.
Right.
I'm trying to end up seeing what is it, and you get there, I know. What is it that we need to end up fixing? You want everyone who is a defendant, that for the defendant to be able to end up choosing who they would bring in. Can't they just cross-claim a defendant in if they're not in there? Or can't they just plead? Can they do other things to end up getting them in the courtroom?
It's very difficult. The statutes and our state law are intentionally drafted.
And I'm picking on you for this because I know you come from a good firm. You can answer these questions. And so just the question is that how do you get them there to be able to answer those questions? Because they say, well, y'all didn't put them in there because they weren't in the case. But isn't there ways if you want them in the case, you're defending a case, say, hey, this is a necessary person right here. They haven't settled. I might want to add them in, and you can do that from the defense side, correct?
Usually the answer to that question is no. Usually you cannot bring them in.
And tell us why you cannot.
Frequently, the only claim you may have against a co-defendant is going to be some sort of a claim for an indemnity or a contribution provision. And that under our state procedures is generally not allowed.
Can you join them?
I'm sorry?
Can you join them?
The best way to do that, Mr. Chairman.
The best way I'm saying, can you?
Usually a defendant does not have the right to do that.
Don't have a right.
Under certain unusual circumstances, you may be able to. But the phrase that we commonly hear is that the plaintiff gets to choose who they're going to sue. And there's valid reasons for that, of course.
But don't you get to argue to the jury that somebody's not here, the empty chair? Don't you get to make that argument? That
Absolutely.
Look, they sued us, but they really should have sued that guy. Mm-hmm. And if the jury believes that it was that guy who was at fault, then you in a way, you do invite the jury to assign fault to the empty chair. Is that right?
It is right, and that's part of what confuses the jury, because at the same time that argument is expressly allowed in the statute, the jury is also expressly required to still apportion 100% of all fault. And juries almost every single time say, I don't know what I'm supposed to do in that situation.
But you can always point to those that are not there. I've seen some people that's very experienced say, well, what would Mr. Jones say? They had a chance to bring him in and he's not here. And so you can make those arguments to the jury and say, well, you know what, guess what? So-and-so is not here. They didn't bring him in. They could have brought him in.
Absolutely.
And you just talked about early on very, very eloquently is how smart these juries are.
And part of the point in me making that comment is exactly this element of confusion. Because when you have an empty chair defense, when as a defendant, you are saying I'm not liable, that other person or that other entity is liable in whole or in part, then the jury naturally wants to say, okay, I need to allocate liability to that person, but I can't. I'm forbidden from doing so by law. And juries do not know what to do with that because it's
Why
confusing.
wouldn't they then? Because if that person is there and they could lessen it to the other folks that are on the defense side, or they could lower the verdict.
They could lower the verdict. Well, the statute prohibits them from doing that as
No,
well.
no, they don't lower it. They don't lower it on their paper. They say, you know what, I would normally give the jury can say I would normally give them
Okay. So
$500.
if I understand your,
I would normally give them $500. I'm only going to give them $300 because the other person is not here that should be here.
if I understand your question correctly, Mr. Chairman, to do that, a jury would most likely have to violate the instructions given to them by the judge. Juries may do that, but the judge is generally going to instruct them to allocate 100%.
100% of their number. He's not going to tell them what number to give.
Well, the statute does say that they are not allowed to reduce the finding of the plaintiff's liability based on that
Not the
plaintiff's
liability,
percentage of fault.
the amount that they assign to it. The amount that
Are you
the jury is,
distinguishing
the
between
amount that
liability
the
and
jury-
fault?
the amount that uh, yes, I'm distinguishing the difference. The percentages will add up to the amount that they are going to end up giving them, but they could decrease the amount based upon what they are going to end up giving for the case, and they assign that portion. Because normally if the case is worth X amount of dollars, they can do whatever they want to.
And to do that, a jury would most likely have to go against the jury instructions.
Yeah, I disagree with you on that, but go ahead.
Yes.
Sure.
So this is the empty chair defense. That's what you're talking about, correct?
That's correct. Yes.
If a empty chair is a settling defendant, do you get a set off for that?
So you're getting back to both the statute and the Smith v. Tiffany case, I believe.
Yes.
Yes, you get a set off as long as it's the same claim, same
Yeah,
liability.
yeah, no, you
Right.
got three people involved, three different defendants involved, one of them settled.
Right.
And so whatever they settled for, you get a set. If they settled for $1 million and the jury came back with $3 million against the other defendants,
Correct.
you'd only have to pay $2 million, correct?
In that scenario, as long as they're settling for the same cause of action, that would be correct. There's
Well,
lots of ways that gets manipulated.
Well, if it's not the same cause of action, if it's not
Correct.
the same conduct, then it wouldn't be an empty chair defense because they wouldn't be involved in whatever you're being sued for, correct?
Not necessarily, because
Now, look, you litigate, I've litigated a few of these cases.
sure.
Not necessarily is not an answer. I mean, you and I, we make a living out of arguing not necessarily, correct? Isn't that what we do? Judge, that's not necessarily the law, or judge, that's not necessarily true. Had a case years ago.
Oh Lord.
No, but this is, and the Supreme Court affirmed everything we're arguing about here today. A young man at a high school climbing a climbing wall that was sold to them by a company, and they're trained. There is something called, and he's being belayed by another student. There's something called, and the belay involved wrapping that rope around something on a belt. There's something called a gree-gree, and the gree-gree is like the device on your seatbelt. If something pulls, it grabs. This company didn't sell that $3.95 piece of equipment with their climbing wall, and didn't think it was necessary. Hired experts to testify it wasn't necessary. A young man, 2 weeks before graduation, full wrestling scholarship to a college, fell 50 feet, snapped his neck, quadriplegic. Okay.
Okay.
Now, the young lady that was belaying him initially was sued, and we settled out with her.
Okay.
And the argument was they ought to be able to allocate fault to her. They talked about her.
Right.
They did. I mean, they argued to the jury. She bears responsibility, and the jury returned a verdict, pretty good verdict actually. And the point was that the jury understood that she was responsible in some way. And I believe, in talking to the juries, they took that responsibility into consideration. She didn't make any money off of selling the wall. She's not the one that didn't provide the gree-gree and all of that. So my experience with juries doing this is they're smarter than you say they are. They're not confused. They understand that empty chair, if it's got liability, ought to be allocated something. Now here's the okay, and if you're going to get a set off, shouldn't the jury be told this person's already paid $1.5 million?
That does make sense.
Well, why couldn't we do that?
As far as set off goes, there's also significant challenges in how the system is applied. May I give an example? A real life example, actual case. I'll withhold the name so that we don't implicate anyone. This particular one happened to be a dram shop case. Many of my cases are not that, but this particular one happened to be. 2 months or so before trial, there were two defendants, two different restaurants. 2 months or so before trial, one of the defendants settled their case for $2 million. They paid $2 million to the plaintiff. The non-settling defendant is not allowed to have a say in how that $2 million is allocated because that settlement is between the plaintiff and the settling defendant. They allocated that settlement to their survival claim, even though the plaintiff was killed instantly because he had an internal decapitation. We attempted to object to that on the basis that there was no survival claim. We were not allowed to object to that. And therefore, when the plaintiff went forward against the remaining defendant only on a wrongful death claim, we were not allowed to set off any portion of it because it was allocated to a different cause of action.
You should not.
So there are ways that it can be manipulated. And
Well,
it happens.
it could be manipulated. Let me say this. Did you appeal that?
We did not.
There you go. You made the law. The Supreme Court didn't. If you felt that was improper, you should have appealed it, right?
I don't know if I can speak to that at this particular moment, but that's the type of example that we see on a fairly regular basis.
But a judgment that may
There's
have been
other
a mistake.
examples as well.
That may have been a mistake made by a judge, and that's why we have the appellate process. Trust me, I understand the appellate process because I lose probably more times than you lose. So, I'm just saying that is you're telling us about something that happened that did not get vetted by an appellate court.
In that particular instance, that is a correct statement.
Usually when that happens, though, everybody has to be on notice, and whenever they are, they have to end up having a basis for it to end up having a survival claim. It does happen. It does happen, but you get a chance to everybody gets notice that there's a settlement. You get a chance to say we're going to object to that settlement because we don't want that allocation to be on the survival claim because we got to litigate it. We think that person died instantly.
Sure.
And it just happened. And so most of the times you see they're not gonna end up objecting until they want to play Monday morning football. I wish I'd have bet on the Kansas City Chiefs as opposed to I didn't bet on either. But the thing is that you can't do that after the fact. I get the point that you're saying. We're not trying to end up making it necessarily easy on one side or the other. We got a heck of a balance here. Mr. Thompson, we got a heck of a balance for these victims. That's who we're going to hear from too, to see what do we do to make them as whole as we can. How do we make it a fair playing field? And one of the things that we had was that I know you don't do bars and restaurants, but how are we going to make this thing reasonable for them too to end up having business? Mm-hmm. And contrary to the popular belief, in our conversations that we have, that's why we are taking a deep dive into this insurance stuff and this data, because we're concerned. We don't want a mom and pop shop. We don't want a bar, restaurant, whatever it is, to make certain that if they're paying more premiums paying a lot more payouts than there are premiums from the insurance companies, we got to see whether we got an insurance company problem or we got a problem that's on this other side here. And that's why we're taking the very deep dive. And you shed some light with this, and you answered the questions really, really well. So thank you.
May I summarize comments?
Yes, you will. But after we finish the
thank you.
and then
Yes,
we're
Senator.
going to hear from the other folks.
Okay, so what is your specific recommendation?
Thank you. That takes me directly to the summary that I was going to share. The primary concern that the people that I am speaking for have is to get to a point where a defendant in a lawsuit is held liable for that defendant's negligence, if any, not for the negligence of others. And the primary provisions that seem to be presently hindering that are in subsection C of 1538-15, which is the part that allows or that does not allow allocation of or apportionment of fault to be made to anyone other than a defendant or a party to the case at the time it goes to the jury. So my recommendation would be to revise that statute to allow apportionment or allocation of fault to anyone who actually had fault, not only to the individuals or the entities that are named defendants, named parties at the time that the case goes to the jury.
How would you determine, then how do you determine the fault of the empty seat? Someone was already settled through
How do you determine
discovery,
their percentage of
depositions?
fault? The
Yeah,
jury-
how do
jury
you,
does
how,
that.
you- how do you engage in discovery with that individual and determining, what actually happened and how much we should?
If I'm understanding your question correctly, Senator, the process is no different than the existing process, whether it's the discovery part, the rules of civil procedure, or the rules of evidence. You apply the rules just like you would in any other way.
They have to pay for the defense to defend themselves after they have settled it and put themselves in that position. They would have to go through the discovery process and interrogatories and all that kind of stuff still.
Only if they are treated just like any other third party.
So how is that, not, maybe it's rhetorical, not for you to answer, but how is that judicial economy? And then how will we ever end up getting all the cases tried? Because there's no incentive then the incentive is lessened then for those to end up having settlement. And we have made a whole practice change into making certain that we can have this promotional judicial economy and to keep folks out of the court systems.
Sure. And I don't agree with the assessment that there would be less incentive to settle the claims. I don't think that's the way it would play out. I don't think the experience of folks on my side of the V would reflect that. I think you would still see a very similar practice and procedure with regard to mediations, settlements.
You never try to contribute to a negligence case 100%, like 1% fault on the plaintiff side, have
Like
you?
the way you would have in North Carolina
Like the way we had here.
before 2000 and
Yes.
before Nelson and concrete supply.
We've seen them all, construction and all of those. We've seen them all. So
Sure.
I appreciate your perspective. I think that is interesting. You did a really good job today.
Well, thank you very much. And I'm happy to answer any other questions if there are any.
Mr. Chairman, I have a couple of
Senator
questions.
Senator from Lancaster, York, and other places.
When you first came up, you made a comment about this 533 as it relates to liquor liability. Do you believe that 533, if passed as written, will make a meaningful change to liquor liability in South Carolina?
I believe it's one piece. I don't think that it is the full solution to the perceived problem.
What are the other pieces?
When I look at a liquor liability, or what we sometimes refer to as a dram shop case, a phrase that I use myself, this is my phrase, this is not anybody else's phrase, is we have a perfect storm. That I've counted 5 things that coincide that create a significant problem. One of them is subsection F of 1538-15 that eliminates joint and several liability. That's one. 2 is that when there's an alcohol involvement or drug involvement, that you don't have a cap on punitive damages. Standing alone, I'm not saying that's a bad thing, but when you put all these 5 things together, these are what I believe to be causing this issue. The third is the allocation provisions that I was just referring to. The fourth is that we have a standard for the restaurant or bar as to what they have to do to determine if a patron is intoxicated. That does not exist anywhere else in the United States that I'm aware of. The concept of by any reasonable means, quote unquote, that comes out of case law. And then the fifth of this, what I refer to as perfect storm, is the statutory $1 million insurance requirement that is a blanket requirement to all sellers of liquor or beer, alcohol, that has no variation or no dependence upon that individual business. Any one of those 5 is not necessarily problematic taken alone. But when you put all 5 of them together, in my assessment, those are the factors that come together and are causing the problem that we see with liquor liability.
A few minutes ago, you talked about 1538-15C.
Yes.
How you believe if you could point to one thing and we could fix it, fix that, 15C. If we did just that, if we took verbatim what is in 533 and adopted 1538, 15C as is, y'all good?
I would be pleased with that. I would be happier with more,
Well,
but I would be pleased with that.
and I guess it kind of comes back to the grand, I wasn't in the legislature in 2005. So I didn't get to sit around and talk about the grand bargain that was made. But at some point, a grand bargain was made by both sides. And the law that came out was eventually struck down and by our Supreme Court and or changed by our Supreme Court, what everybody thought the intent was. Let me make that a little better. 1538, the changes in 1538, 15C change that bargain back and say, this is exactly what we actually bargained for in 2005. This is what we agreed to in 2005. Okay. So if we made those changes and we brought you back to kind of that 2005 time period, and that's what this bill said. Because everybody, I keep hearing from people, well, all we want is what we bargained for in 2005. I hear that from a lot from the outside, not from you per se, but from the outside people. If we change 1538, 15C, that's it, correct? That's fixing that language so that you get the bargain you asked for in 2005. That would do it.
I don't know that I have the historical context to answer it the way you're phrasing it, Senator.
Not sure I do either. So.
I would say two things that I think might be on the fringes of what you're saying. One is that there's a little word and a little phrase here and there that are not in C that I think would have to be adjusted. You know, if you adjust C, you got to adjust A or something like that.
Certainly, cleaning up language makes sense. Yeah, that's just housekeeping.
Right. And then the other point is the goal of the comments that I'm making is what I tried to allude to earlier, to make each party liable for its own negligence and not the negligence of others. If that can be achieved, then I think that's one of the primary thrusts of what this bill is trying to go to.
So, and one last thing. So we all get to these cases. I had a case once and I just say $3 on one side, $2. And so it was a couple of defendants. They came in, big company, civil conspiracy, $2, wrongful termination, distributorship, $2, punitive damages, $1. And I know the jury was trying to give them $5.
Okay.
We had two causes of action for the plaintiff, and they could only end up getting $3. They could only get $3. Let me get this right again.
I think you're losing me, so I'm sorry.
No, I'm not losing you. I'm telling you who lost. It was $2 on the plaintiff's side for each one under that cause of action. For the civil conspiracy and the wrongful termination, $2 each. Punitive damages too. Two bad acts that they attributed. They had to elect which cause of action they were going to go forward on. Maybe something different. I'm going to segue into this because the juror came to my office afterwards and said, "Hey, we gave you $5." I said, "No, you didn't. You gave us $3." Okay. And so we segue into in these kinds of cases when we play this on the side of the defense to make certain that we can do the allocation, and then a person walks out, they have these injuries, and then all of a sudden they are injured for life and have these other problems, and they end up on the Medicaid rolls and this kind of stuff. Then how do you balance that? And you don't have to answer that question now, but it's something to consider because we send these people out on the state's dime. And so we have to end up having a balance. It's not going to be a perfect system. I do cases on both sides, and I've done that for most of my career. And so I hear what you're saying, but with all due respect, there's a lot of history into this that goes in there that's not within where you are now.
Understood.
And so I just want to say that that's something that we're going to also consider. But thank you again for being there. I'm not even going to ask you to answer it. I'll have a conversation with you later on about it, because I think that there's
Be happy to.
another side of the folks that are being hurt, not only physically hurt, but financially hurt as well. Last question here. Since we're going to do some tort reform, maybe you want some loser pay?
Oh, let's take one step at a time.
No, no, you don't get a chance to do that. We do. So would you like loser pay?
Loser pay is very complicated.
This is complicated. You want loser pay, and I'll give you a chance. Say, Senator, I prefer not to answer that question. I'm not prepared for that. Would you like loser pay?
I am not prepared to answer that tonight.
Do you ever use Rule 11 on the defense side?
Occasionally,
Have you ever used it?
yes.
Like how many times?
Fewer than.
You don't give numbers. It's like my children. I say, how are your grades? Good.
Would you believe I was a math major?
You sound like you've been a math major. You're pretty smart guy. I appreciate you.
I don't know the answer to how many times have I used it. 5 or 6 in 17 years? Not frequently.
That's a lot.
Mr. Chairman,
Yes,
just
sir.
very briefly, you described the insurance or the laws surrounding liquor liability as the perfect storm just a moment ago,
Again, my phrase.
your phrase. And the perfect storm because it makes the folks that sell the most dangerous substances sold legally in our state more liable than other folks, is what you're basically saying. Is that correct?
I wouldn't characterize it that way.
Well, you know, we have the second highest drunk driver fatality rate in the country.
Okay.
And the people that you're talking about, these defendants, are the people selling the alcohol to get people in a position where they're killing other people with their vehicles, correct? That's what they're accused of.
That's what they're accused of. And
Okay.
again, I wouldn't agree with the characterization all the time.
Well, I
but
understand,
sure.
but so why would we want to make it easier on them? They have a requirement. Why do you care whether your clients have $1 million in insurance or not? Do you think that makes them an easier target? Or is it the folks that are severely injured by drunk drivers may have a chance to get their medical bills paid? Or if they lose, recently had a case where they lost the breadwinner and the breadwinner's daughter. Not only did they lose, I mean, and all they can recover is $1 million. I mean, the drunk drivers are killing us. Your clients are getting them drunk. At
I would
least.
disagree with the assessment, but
Well,
carry
I
on.
understand you don't disagree with my assessment. Juries agree with my assessment in many, many instances, or better yet, y'all write the $1 million check and move on. So I'm not interested in adjusting our liquor liability laws. I'm interested in making sure the insurance companies differentiate between a dive bar that's serving $1 shots and a restaurant that's serving food with alcohol. And that's not happening. That's not happening.
And I commend that interest. I think that is very valid.
So the dive bar gets put out of business because they can't afford the insurance, and the restaurant's rates go down. I mean, it seems to me that's the perfect solution without having to deal with what you call the perfect storm. I call the perfect responsibility law for bars that overserve or serve underage kids that result in other people getting maimed or killed.
Part of the challenge that we see with that, Senator, are, again, anecdotally, examples like what I just heard from the owner of an upscale string of restaurants in the Greenville area 2 weeks ago, who said that in the past 24 months, they've had 0 claims and their liquor liability insurance premiums went up by 45%.
Well, you know, and what we've heard is the insurance companies don't have to disclose why they've done that. That's something I think we can fix relatively quickly and may solve all your problems at the same time.
It may.
Okay, thank you.
All right. Well, thank you again for being here, Mr. Thompson, and appreciate you tolerating our questions as well. And this may segue into our next one. And folks, I know we've been here for a little while now. I think some folks have traveled. We want to hear from them, but thank you for your testimony today.
Thank you.
And we'll stay in touch. No, we got Twyla. Is it Twyla Reynolds? Okay, Miss Reynolds. You can tell us. So first of all, we're swearing every witness.
Yes, sir.
If you would raise your right hand You swear affirm to tell the truth, whole truth, no, nothing but truth, so help you God?
I do.
And the next person, you do what's your name? Miss Bridget Green, okay? You may proceed.
Thank you. Can you hear me okay?
And pull your mic closer if you can.
Okay.
That's good.
Is that better?
It's much better.
Okay. My name is Twyla Reynolds. In South Carolina ranks second in drunk driving fatalities. My son Jonathan was one of those victims. One of my daughter's best friends was one of those victims as well. My daughter Lucianne, there, and my daughter-in-law Bridget were also victims. But by the grace of God, they survived and they're here with me today. But their lives are forever changed. My life is forever changed. And I'm now the primary caregiver for Lucianne as she continues to heal. It's a daily struggle, but we have faith and we're staying strong. I'm here today to speak against any law that protects those who put drunk drivers on our roads. Our state needs to do better in enforcing the laws that we already have instead of relaxing or changing the laws. The wreck that forever changed my family is a result of bars putting profits over safety and no one doing anything about it. My son was driving home on the Hilton Head bridges with his wife, my daughter, and two of their best friends when a drunk driver driving the wrong way on the bridge hit them head on. His truck flipped over the side of the bridge and it landed in the waters below, and that driver died. My son was killed. My daughter's friend, Jordan Johnson, she was killed. My daughter was gravely injured and forever changed. My daughter-in-law is blinded in one eye, and their friend Jordy Delseed, he was a backseat passenger, and he also suffered a traumatic brain injury. In this case, who's responsible for the senseless deaths? We sued a group of bars on Hilton Head Island that overserved the young man that was driving the wrong way and hit my family. That was not a one-time thing. Enforcement testified that they regularly found multiple people passed out in the bushes or cars outside of the bars. On Friday nights, the question was not if they would find someone passed out, but how many they would find. So in the 5 years leading up to the wreck, the sheriff's department had over 4,000 calls for service to that one address on Hilton Head. They needed to be held accountable, and the current law, as it is now, allowed for us to do that. Does anybody know, or can anybody tell me what the foreseeable future means? Is there like a time frame that anybody can put on that? Because I've been trying to figure it out. And the reason why I ask that is because every time we go to the doctor and I ask for a time frame on when my daughter's going to be better, when can she drive, when can she get back to a normal life, and they say, well, not right now, and this is the way that things are for her for the foreseeable future. Lucianne, my daughter there, she suffered a traumatic brain injury, 3 different kinds. And so from that, she has acquired ADD, memory loss. We're rebuilding her mouth, and her optic nerve is paralyzed. And so there's, a few things that we have to get through. So for the foreseeable future, I'll be taking care of my 25-year-old daughter. My daughter-in-law, she is blinded in her left eye, but she's still doing wonderful. She has a couple of surgeries ahead of her. She had her recent surgery in October, and she has surgery on her arm to stabilize her arm. So a few more to go as well. They both attend weekly and biweekly therapy appointments, and there's not an end in sight. So everything is the foreseeable future. They both take more medication to get through the day. They came from taking a multivitamin, but they both take more medication to get through the day than one person should ever have to take. For my daughter, Lucianne, she's always been very inquisitive. She's very intelligent. And those words have been just kind of replaced by, she's not able to do this and she's disabled this way and whatnot. That's a problem for me, because she didn't have problems prior to this accident. And so, but she's always been very inquisitive. And so now when she asks me, Mom, how much longer is this going to go on and when is this going to end? I can't answer that question for her. While our case was going on, we've heard people say that, The law is a problem because it's closing restaurants and bars, and that anyone can be sued for serving one drink, and that's not true. On the night of the wreck, the drunk driver that killed my son had his first beer at a restaurant in Bluffton. He then went out to the Triangle on the south end of Hilton Head and had multiple shots and drinks before driving back into town. And we didn't sue the first bar that he went to because there was no evidence that they broke the law. They didn't do anything wrong. So for a bar to be held liable in a dram shop lawsuit, they have to break the law, and their doing so must also contribute to whatever harm was resulted. So if we change the current law, it'll not only protect those who break the law. South Carolina already ranked at number 2. We change it, we're going to number 1. So how many more people have to die? Under the current law, there's 3 requirements in South Carolina when it comes to establishments that sell alcohol. Don't sell to anyone under the age of 21. You can't sell to someone who's already intoxicated, and you can't make a third-party sale. Third-party sales is purchasing for someone who is intoxicated or who is underage. It's not hard. Doesn't mean fixing. We have to enforce it. We need the people in place to enforce it. Why is that the law? Most people think that it's because the person could get behind the wheel. That's a part of it, but it's bigger than that because it's about the person getting behind the wheel and making a bad decision, harming themselves or harming someone else. And that could be playing in traffic, playing with a gun, or driving. South Carolina clearly has a serious and worsening drunk driving problem. 1 in 3 South Carolinians is impacted by drunk drivers in their lifetime. There's never been a worse time to consider loosening the responsibilities of those who might put drunk drivers on our roadways and then calling it the Justice Act of all things. This shows me that businesses who have been found liable have too much power. Please let's find a way to combat drunk driving instead of making it easier to profit off of. And let's find a way to make our roads safer. Thank you.
Right. Any questions of Ms. Reynolds? We're very sorry about your loss. Thank you. It's very brave for you to come over here and to tell the story. I know every time you have to tell it, it brings back those memories, and it's not that easy. And so we all pray for you, and we agree with you for your loss.
Thank you, sir.
You have something you'd like to add, ma'am? Okay. Any questions? All right. Well, thank you again for being here. We had a couple of other people that came that wanted to end up talking to them. Richard McLawhorn and Lowell Cogart. I don't know if I got it right. Carver. And we're gonna. Are you guys from this area? Aiken. Well, come on up briefly from Aiken. Yes, sir. Okay, Mr. Cogart.
Yes, sir. Lowell Coppert.
Okay. You swear to tell the whole truth, nothing but the truth, so help you God.
Yes, sir, I do.
Okay, thank you.
Thank you for having me this evening. I am a combat veteran of the U.S. Army Special Forces and a small business owner. I speak to you today as an advocate for veterans and a past commander, a veteran of Foreign Wars Post, Savannah River Post 5877 in Aiken, South Carolina. Our post closed its doors last year due to the issue at hand. If not for the dedicated volunteers that make up the current ranks of this post refusing to lay down, it would still be closed. The issue, while being an attack on most institutions' livelihoods, is not for us. It is, however, an attack on our lineage, a lineage that from my post dates back to September of 1952, when 69 veterans, most returning from combat in World War II, formed our post. You may be familiar with one gentleman, his name, Strom Thurmond. Most passed a statue of him right outside as we entered the building earlier today. I'm here to tell you, we are tired. We're tired of 2 decades of war. We're tired of burying our brothers and sisters, and we're tired of being paid lip service. You see, duty isn't part of the job. Duty is the job. You raised your hand, every one of you, and you asked for our votes, but we continue to hear how hard your job is. We raised our hand as well. We raised ours to protect our freedom and our just way of life that we all enjoy. We simply want a civil justice system that holds people accountable for their acts and not someone else's actions. So we compel you to create a system that holds all South Carolinians equally accountable. More than 400,000 veterans that call South Carolina home are counting on you to do the right thing. And may I just add, as a combat veteran, inherently dangerous is conducting combat operations. I don't think owning a bar would be very high on that list. Thank you. We're asking you to create a system that's fair and just for all South Carolinians and hold everybody equally accountable. And I think that's where a lot of people are upset on this issue, is people aren't being held accountable, like the bar that this woman just spoke about. I mean, when a law enforcement entity comes out to speak with her and tells her that this has occurred this many times, we know that people are laying in the bushes. That's not a problem for my VFW. That's a law enforcement issue. And it's not an issue of you all creating law. It's an issue of the law not being carried out. It's an issue of judges allowing people to come in and walk out the door. The woman who was rear-ended and lost her life in Charleston on a golf cart, from what I understand, and don't quote me on this, I'm not a lawyer, was that defendant, that was their 5th DUI. How do you get to that point? I mean, how are you out, not even just operating an automobile, how are you out just to enjoy the same liberties that all of us are enjoying right now? That person should have never seen the light of day. They should have been in jail and not driving down that road in an automobile. And it goes back to accountability. That's what we're asking for.
So are you concerned about VFW posts
Yes, sir.
being closed down? Is that a primary concern you have?
Yes, sir, it is.
And you think that do you think that there are some establishments that should be closed down, people in the bushes, but not the VFW posts? Is that what you're saying? There ought to be enforcement on some that are the bad actors,
Yes, sir.
but don't punish everyone with what? Higher
Mass
insurance
punishment
rates?
is what we're
higher
asking you not to enforce. Mass punishment for people that are not breaking the law. And that's what currently is happening with the insurance
because
rates.
that's driving your insurance up.
Yes, sir. And the other thing, so the last hearing we had, they spoke of 48 insurance carriers. When we close our post, I can assure you that there are 48 carriers out there, but not of all of them apply to a place like a VFW or a Marine Corps League or a place that does not serve food as 70% of its revenue. We are a unique situation. So there are only a handful of carriers that will even do business with us. So it's not 48 for us. It's much less.
Did you close? Is your post closed?
It is back open as of today, but I
Was
don't
it
know that it's
closed
going to be
because-
able to sustain being open any longer because of the rising cost of our liability
Was
insurance.
it closed because of the liability
Yes,
insurance
sir, it was.
cost? And how long was it closed?
2 weeks.
And what type of, do you have any data on the increase in the insurance premiums that you experienced that led to a
I
closing?
do not with me because I'm not the current commander. I can't get you that information, but I can tell you that the post in Isle of Palms shut down permanently because their liquor liability went up an additional $70,000 for 1 year. They are no longer open.
Yeah, I knew about that.
So
That's where
is-
I'm from.
So is that an insurance? Is that an insurance issue in your view, or is that something else? Because what we're challenged by is we like to see that too.
Yes,
And
sir.
so the one thing that we have not been able to get is that these the data from what they're reviewing to see how they do the rates. Because if you may, I don't know if you've been following it, but they are exempt, so there's no regulation of it.
Yes, sir. I understand that. And let me be clear. I was a Green Beret in the United States Army. I'm a gun toter. I'm not a lawyer and I'm not an insurance man.
I'm a gun toter and
but
a lawyer.
These guys behind me are insurancemen that are very well versed. Most of you are lawyers that are more well versed than I am. I'm not. I can't speak on any of that.
We're here for your experience, and if you don't know, you don't know. But the thing is, we can't castigate things that we don't know, and so what we have to be certain of is that we're trying to get the data that is driving the issue that makes the rates go up. We understand the bad acts, bad actors, whatever that's going on that's out there. We're getting the comments from both sides. This is not hard. What you've done is hard, but this is something that we chose, and it is service. And the thing that's going on now is we're trying to get an answer. That's why we're listening to you. We're trying to listen to every side, and whenever it comes together, we'll make a decision, good, bad, wrong, or right, and it will be our decision. But we'll do it collectively. We don't come from the same place.
Yes, sir.
Senator from
I think
Orangeburg.
the bigger issue lies in accountability. And
I think everybody
that,
wants to be accountable, sir. I mean, you use that word several times. I mean, I've been accountable my whole life, and
and
just
you
want-
are, but now, what I'm saying is the people that are out there like that bar was
I
not
agree with
being
you.
accountable.
I
That's
agree
that's
with
what I'm
you.
getting at.
I agree with you. And
But my veterans where I live at are being held accountable for the
They-
bad acts of another
they're being
institution.
responsible. They're holding them responsible because they're fit in
sir.
the same pool. That's
Exactly.
what you're saying. You use the word accountable. Senator from Orangeburg.
Do you know whether y'all had any claims arising out of
We do not.
alcohol sales? All right, so that's sort of that is the problem. I mean, if a bar does have people laying in the bushes and it already has 3 people that have been convicted of drunk driving coming from that bar, then just like if you get in a wreck or you get speeding tickets, you can expect your insurance to go up because you're a bad actor, you're a higher your risk is higher, and so the cost to you ought to be higher. Seems to me that the insurance companies, without any oversight or regulation, are just, I guess, they're either spreading the risk or they're unduly profiting on people because I guess they just give you a premium until you take it or leave it. You don't get to negotiate it. The only thing you get to do is shop around, go to another carrier, see if somebody will offer you a better rate. But if they're all operating under the same system where there's no oversight, they don't have to justify why they increased your rates. They just did it. Is that right? I mean,
Sir.
did they give you an explanation?
Not that I'm aware of, and I can get you that answer. As I said, I'm not the current post commander. I'm a former post commander.
Okay. All right. Thank you.
Thank you. Yes, sir. Thank you for the opportunity to speak.
Having this, it's been a long meeting because folks have been thirsting to talk, and we had to get the expert testimony in. But also, this committee is going to be moving fast. We still got some more work to do. And those that need to have something to say, we'll have you to contact Sharon, and we'll try to get another meeting established here pretty quickly.
Thank you,
Well,
Mr.
let me give you take the. You swear to tell the whole truth, and nothing but truth, so help you God.
I do.
Okay. Yes.
Thank you, Mr. Chairman and members of the committee. My name is Richard McLawhorn. I am a defense attorney at Swinney, Wingate, and Barrow here in Columbia. I actually practiced for a couple years in Hartsville, right
know.
next to your office, Senator.
Yes, sir.
Very nice view. Really love Hartsville. So it's a pleasure to be before you today. I wasn't around in 2005 when 1538-15 was passed. I was in college. I have seen the effects of this law come into effect over the last 13 years that I've been practicing. And there are certain inequities that have arisen as a result of how the law has been implemented and interpreted. In fact, very often there are cases in which there are deep pocket defendants that everybody understands to be mostly not at fault for the injury of the plaintiff, who are ultimately forced to pay the entire verdict. In fact, I know there was a question earlier about nuclear verdicts. Obviously, when an attorney like me goes and evaluates a claim with my client, you look at the potential exposure. And when you go to mediation, what generally happens, and there are CLEs taught in the plaintiff's bar on this, you settle out with the small fish first, and you keep in the deep pockets, regardless of whatever responsibility they have, because the goal is to exert maximum pressure on the deep pocket defendant. It's a common tactic, happens all the time. And I've been in a number of mediations where the plaintiff's attorney says, you are going to be the only defendant on the verdict form. You need to pay us X amount. Because the fact of the matter is, when a jury goes back and deliberates, they assign fault to the defendants on the verdict form. I've tried a number of cases. I've done a number of mock jury exercises where you get to peek behind the curtain and see how the juries deliberate. And the fact is, when they go back and deliberate, they say, we are not here to discuss what X, Y, and Z non-party did. We are here to talk about the people on the verdict form and to assign fault to them. Oftentimes, there is a plaintiff who is completely innocent. So there's no chance of any fault being assigned to that plaintiff, but rather you have a defendant that most people believe is mostly not at fault being 100% responsible because that's the only choice the jury has. I want to point out, by the way, that S533 does not change the fact that if a defendant is 51% at fault, the defendant will still have to pay the whole verdict. We're only dealing with a situation in which a defendant is less than 50% at fault for the plaintiff's injury. So for that reason, I do believe that this law is fair and would correct an inequity in which we are seeing defendants who are mostly not at fault for an injury being responsible for the majority of the damages. I do also want to address very quickly one argument that I think was raised, that S533 would protect bad actors. Again, a bad actor could be 51% at fault and have to pay the whole verdict. Secondly, a jury has an opportunity to assign punitive damages to a bad actor that they believe needs to be punished, regardless of their percentage at fault. A jury could find a particular bar to be 40% at fault for the plaintiff's injury and still issue a large punitive damages award against that particular bar at a second phase. It doesn't eliminate the ability for a jury to punish a bad actor. I think that it's fair and equitable for a defendant to be responsible for their percentage at fault. I think that's, I don't know if that was what was intended in 2005, but I do think that that is what should be enacted. And I'm happy to answer any questions if you have any left after Jay.
Okay, any? Glad you spent some time in Hartsville. Martin Driggers was working with you then, wasn't he?
That's correct.
Yeah, good lawyer, good friend. And so thank you for doing that. We'll continue to end up talking to you and welcome your suggestions, okay?
Thank you.
So committee is, I think we got some more work to do. I want to end up trying one last time to see what, if anything, we can do with the insurance information, any data that would end up driving it. It looks to me that we have a couple of separate issues here, not a lot of issues as it relates to joint and several. It seems to be whether or not that folks want it or not, but to see if any of these other drivers will end up getting us there. And so the liability issue for restaurants and bars is a question. We're going to see who wears the face of that issue and see what happens with these premiums that are being paid. And so I think that I'm going to interrupt. I think, Mr. Smith, I saw did I get your name right? Mr. Smith? You and your wife are here. You can speak very, very, very brief. I'm sorry. She was sitting behind the podium. I couldn't even see her. So you walked out.
I'm short.
Raise your right hands. Swear to tell the whole truth, nothing but the truth, so help you God. Okay.
So the committee members don't know, my name is Randall Smith. This is my wife, Karen
You got your microphone on?
Green.
Yes.
Can you hear me?
Yes.
I'm here representing Boating Safety South Carolina. We were instrumental last year in getting the requirement for boater education passed, and thank you very much for passing that bill through the Senate last year. Governor signed it this summer. I've sat here and listened to both sides of the argument. And as a layman, what I've taken away from it is the fact that you that are trying to decide on a fix for this don't have all the information that you need. And you can't assure us that this bill will fix the problem. We've had testimony says that it won't. I don't know. Are the insurance companies ripping the businesses off? Can you tell me that? I don't know. it's a possibility. I do know this, and I will ask this last question before I leave. Can you assure me that this legislation will not harm crime victims, families that have lost individuals because of bad actors, voting accidents, DUIs, DUIs? That's who I'm looking out for. Thank you very much. I appreciate you giving me the opportunity to speak.
I just have just a couple of things to say. First of all, the victims ought to have 100% support. And I want somebody to tell me, in the case we had when my son was killed, how do you say this person was 51% responsible, this person was 10% responsible, this one was 25, and so on? In my book, all of them were 100% responsible if there was anything that they could have done to have stopped my son from dying. Tell me, how do you decide who's 51% at fault?
Thank you.
We're very sorry for your loss as well and your patience. You guys have been working here for a long time, and it's noticed and appreciated.
Since 1998.
Yes, sir.
Long time.
All right. Anything for anyone here for the good of the committee? Turn to the next. And we'll recede until the next call, and we'll be in touch. Thank you for your patience.